Good morning to one and all present here. I welcome you all to the final rounds of this year's International Moot Court competition. All these participants have demonstrated exceptional skills in legal analysis, oral advocacy, and critical thinking. They will be presenting their arguments before a panel of esteemed judges who have taken time out of their busy schedules to be here today. I'd like to acknowledge the presence of Honorable Mr. Justice J. Upadhyay, Honorable Mr. Justice A.C. Rao, Mr. Mehul Vakharia, Mr. Deepan Desai, and Ravi sir for again joining us today and making this event very wonderful. I want to remind you all that this competition is more than just winning. It is about the experience of learning, growing, and challenging yourself to be the best lawyer you can be. So let us begin with the final rounds and may the best team win. Thank you.
The council seeks permission to approach the dais. Much obliged. The council seeks permission to collectively refer to the bench as Your Excellencies. Much obliged. This is counsel number 1, appearing on behalf of the appellants. This is counsel number 1 from TC 17. May the counsel proceed? Yes. Much obliged. This is counsel number 1 appearing on behalf of the appellants in the case of the Kingdom of Zeronesia versus the Republic of Victasia on behalf of Zeronesia. This case is as per jurisdiction of the court under Article 36 of the Statute of ICJ. The council seeks permission to move on to the issues raised. The first issue is whether Abdul and his wife be considered refugees under the existing Refugee Convention. The second issue is whether Abdul and Rihanna could seek protection under right to life under Article 6.1 of the ICCPR 1966. And the third issue is whether Victasia's denial to provide asylum to Abdul and Rihanna violates its international obligations. The counsel number 1 will be speaking on the first issue and 2.A of the second issue, followed by counsel number 2, who will be speaking on 2.B of the second issue and the third issue. The council seeks permission to move ahead with the statement of facts. In this case, there are two countries involved, Victasia and Zeronesia, both of which are island countries. Zeronesia comprises of 114 islands, whereas Victasia comprises of 800 islands. Over the last 12 years, there's a severe effect of climate change, and as a result, out of the 114 islands, 54 are extremely low-lying, and when there's high tides, they're submerged. Again, in 2016 and 2017, a total of 7 islands have again been submerged, and it is also predicted that in the next 10 years, owing to a rise in the sea level up to 2 feet, there'll be a submersion of another 30 islands, leaving only 23 out of the 114 islands to suffice a population of 5.7 crore of the people. There's also scarcity of land space, agricultural land, job opportunities, and drinking water. In this case, Abdul and Rihanna, due to the fear of losing their livelihood, they have entered Victasia. And after a span of 4 years, they were arrested by the immigration officers, and there's a decision for deportation. And thus the couple has sought for diplomatic intervention, and due to the provision that there's a risk to their life, the country is requesting, Zeronesia is requesting Victasia to accommodate them in their country. The council seeks permission to move ahead with the arguments. The first issue is whether Abdul and his wife should be considered refugees under the existing Refugee Convention. This will be dealt in a threefold manner. Firstly, that they should not be considered as illegal migrants. Secondly, that the definition under the Refugee Convention is not comprehensive enough to meet the contemporary requirements. And thirdly, the refugees, they will fall under the category of refugees as per international customary law. So firstly, United Nations Environmental Program, UNEP expert, Essam al-Hnawi defined environmental refugees as those who have been forced to leave their traditional habitat temporarily or permanently because of marked environmental disruption, and that has jeopardized their existence and has seriously affected the quality of their life. Now, climate refugees fall within the definition of environmental refugees, and owing to the rising sea levels and the impacts of climate change, their lives are seriously at risk. At the same time, Article 1A of the Convention relating to the Status of Refugees 1951 states that refugee is a person who has crossed international border due to the well-founded fear of being persecuted for reasons of race, nationality, religion, membership of a particular social group, or political opinion. Now, in the literal sense, although Abdul and Rihanna may not fall under the definition as given under the Refugee Convention, nevertheless, as per customary international law and as per subsidiary protection, they will fall under the definition, which will be explained in the 1.c, sub-point 1.c. Further, moving on to 1.a, which talks about why they shouldn't be considered as illegal migrants. There is a substantial difference between illegal migrants and refugees. So, firstly, it is that while illegal migrants cross international borders voluntarily, or it is their decision to move, there is a condition in case of refugees, because they move into an international country or another country because there's an external factor that's affecting them, and they are left with no other option. So in this case, Abdul and Rihanna, there's a threat to their livelihood. There's scarcity of water. That is a basic requirement for a person to survive. And that is lacking, and that is the reason why they have moved into another country, which is Victasia. Now, the International Organization for Migration defines migrant as any person who is moving or has moved across an international border within a state or away from his habitual place of residence, regardless of the person's legal status and whether the movement is voluntary or involuntary. So in this case, they fall within the meaning of migrants. However, it is to be noted that while they decided to move on to the country, there's an external factor that's forcing them to move into the country. They are left with no other option, and hence the country, Zero Nature, is requesting Victasia to accommodate them. At the same time, the definition given by United Nations High Commissioner for Refugees define people as those who are outside the country of origin and for reasons of feared persecution, conflict, generalized violence, and other circumstances that have seriously disturbed public order and hence require international protection. Here, what is to be noted is the term public order. So as per international humanitarian law, public order is described as a result of impact of climate, as general conditions that must exist so that the individual can enjoy their rights and freedoms. So in the given situation, the country itself, due to the lack of resources, they cannot suffice a population of 5.7 crore. And this leads to a situation where the people in that country cannot meet their requirements, basic requirements like land, shelter, water, other natural resources that are required for them to sustain their life. Hence, owing to the factor that they cannot enjoy their rights and freedoms, they fall within the meaning of refugees as given by the United Nations High Commissioner of Refugees. Again, in the case of Tetiota, where there was migration to New Zealand, United Nations Human Rights Committee added that the risk of an entire country becoming submerged underwater is so extreme that life with dignity may not be possible even before the submersion. So in this case, yes, it is acceptable that there are 53 islands that are still remaining. However, there is a threat that more than 50% of the islands have already been submerged, and it is not possible for them to live with dignity even before the submersion, because it is not sufficient to provide for a population that is 5.7 crore. So it is reasonable for them to migrate to another country, looking out for a condition where they can sustain their life. Now, 1.b, it talks about how the definition is not comprehensive enough to meet the contemporary requirements. So I would like to point out how the Refugee Convention came into being. Firstly, it was adopted in 1951. This was the time when the Refugee Convention arose into the 20th century due to the political changes that were taking place. So the 20th century was marked by falls of empires, leaving over 1 million people displaced. And at the same time, there was immediate requirement to address the refugee crisis. The issue associated was that a lot of countries were becoming decolonized during that time, and there were formation of nation states. This also added to the number of refugees that were there. So this is the background in which the Refugee Convention came into being, and that was sufficient to meet the requirements of that time. But contemporarily, we have certain issues like the people who are fleeing due to threats of protracted conflicts due to non-state actors, persecution by non-state actors, food insecurity, and climate and environmental disorders. So these people are being left without even a status. So they need to be getting the protection under the refugee definition itself, because even they have the right to life. Now, for the first time, the issue of environmental problems only emerged in 1968, while even the topic of climate change came into being only in 1972. So this is to be noted. The problem itself emerged at a later stage. So hence, it is not necessary to limit the definition within the written letters. What has to be seen is the spirit of the letters. So what it intends to do to protect the rights of the people. In March 2018, the United Nations Human Rights Council adopted an outcome document which is inclusive of the issue of cross-border movement of people as a result of climate crisis. So as per this, this document also points out that the definition of refugees as given in the Refugee Convention, although it may not include climate refugees as of now, but it is necessary that the governments of the respectable states incorporate the concept of human rights to ensure that the climate refugees are allowed to live in conditions that protect their human rights. So in this case also refugees, the climate change refugees are incorporated in terms of the contemporary needs, because this came into being in March 2018. So state action should be taken by respective states in order to protect these climate refugees. And 1.c talks about international customary law. So firstly, the council would like to point out that as per international customary law, there's a source, which is derived from state practices. It comes under Article 38(1) of the Statute of the International Court of Justice. As per subclause C, it states the general principles of law as recognized by civilized nations. Now, there are two judgments with regards to this, which gives criteria to identify what are the general principles of law as recognized by civilized states. Firstly, the fisheries case, UK versus Norway. So according to the International Court of Justice, it is stated that state practice is an essential element of customary law can be established only when many states engage in the same practice. And secondly, in the second judgment, which is in the case of North Sea continental shelf case, it was given that when it comes to these state practices that is practiced by many countries, the practice of the specially affected states should be considered. So in this case, we have to understand that there are two criteria. Many states should include the climate change refugees within the definition of refugees, and at the same time, the countries that are doing so should be the ones that are specially affected. Now, when you take into consideration the global impact of climate change, the countries that are mostly affected are the African and Central American states. So they come under the definition of specially affected states. There are two conventions to consider here. Firstly, the OAU Convention, governing the specific aspects of refugee problems in Africa. And this has been ratified by most African states as well. So as per the definition of refugees given here, Article 1(2) of OAU Convention states that the refugees shall also apply to every person who, owing to external aggression, occupation, foreign domination, or even seriously disturbing public order in either part or whole of its country of origin or nationality, is compelled to leave his place of habitual residence in order to seek refuge in another country outside his place of origin. So as per this definition, again the term public order is used. That is a situation necessary to fulfill the rights and freedoms of that person. Similarly, the same definition comes under the Cartagena Declaration, which again includes climate refugees within the scope of refugees. And in that, it comes under two categories, which is when there is massive human right violations and the other circumstances that have seriously disturbed public order. So under these two aspects, again, climate change refugees fall in the definition of refugees. And hence, as a result, because this is something that's affected, that is accepted, climate refugees are accepted within the threshold of refugees by other countries. As per state practice, they should be included within the definition of refugees in order to meet the contemporary requirements, which were not then which was not then present when the Refugee Convention was drafted. The Council seeks permission to move into Issue 2. Issue 2 is whether Abdul and Rihanna can seek protection under right to life under Article 6(1) of the ICCPR in 1966. So there are two arguments to be raised here. Firstly, whether there is a threat of an imminent risk, And secondly, whether they have the right to live with dignity. Council 1 will be dealing with the first subpoint, which is threat of an imminent risk. So Article 6.1 of the ICCPR herein states that every human being has the inherent right to life. The right shall be protected by law. No one shall be arbitrarily deprived of his life. So here it states every human being has the right to life, which means that every human being, irrespective of their age, nationality, race, social group, political ideology, everybody has the right to life. And while interpreting the definition of as per Article 6.1, it is said that it should not be interpreted narrowly but broadly, and this is a statement by the United Nations Human Rights Council. So as per this, it does not just include, or it does not merely deal with the death or life of a person. It also includes those aspects which are necessary to sustain their life, to ensure a life with basic dignity, in basic standards, which definitely includes availability of drinking water, natural resources to suffice their land, land resources, shelter, etc., which are absolutely not available in the country of their origin, which is Xeronesia. And the government itself has stated that there's a threat to the security of the citizens as per proposition. And they do not have sufficient resources to meet the needs of the people, which is 5.7 crore, which initially was staying in a total of 114 islands, and now has come to less than 50% of the islands. So there's a threat of an imminent risk. In the case of Albersberg et al. Versus Netherlands, it is stated that under the optional protocol, the risk of violation of the covenant must be imminent. And the term imminent means that the risk of life must at least be likely to occur, and not that they are actually facing it at this point of time. So it is only that it should be likely to occur, and hence if there's an imminent risk, the countries have an obligation to protect them, be it one's own country or where they're seeking refuge. At the same time, when you consider the situation of Abdul and Rihanna, it is not possible for them to stay in a country where they fear threat. It's not that they are facing it rightly in the moment where they may lose their life or shelter, but definitely there is no resources to suffice their needs. The Human Rights Committee in the New Zealand's case also stated that in the context, Your Excellency, the Council seeks an extension. Okay, it is stated that there are two factors affecting it. There should be an anticipated harm in receiving the state. The anticipated harm in the receiving state influences the assessment of risk. So even if the people anticipate a harm while going back, then there is a risk factor involved in it, and it falls under the definition of imminent risk. And hence, they should be considered and given right or protection of their right within Victatia as well. The Human Rights Committee also stated that the scope of Article 6 is also wider than the International Refugee Law, which deals with non-refoulement. So even if they don't come under that definition, under Article 6, they should be getting protection to accommodate them within Victatia. Much obliged. May it please the court.
Council 2 for the applicants seeks permission from Your Excellencies to approach the dais. Much obliged. Your Excellencies, the Council number 2 for the applicants would be dealing with issues 2B and issue 3. The General Comment number 36, 2018 on right to life, in which the committee established that the right to life also includes the right of individuals to enjoy a life with dignity. Here, the Council would like to state that there are conditions in Xeronesia such as lack of potable drinking water, lack of land, depletion of the agricultural land, loss of livelihood, lack of employment opportunities. All these factors are considered when we acknowledge right to life, and especially right to live with dignity in a state. Taking a note of this statement, the Republic of Victatia would be in clear violation of plaintiff's right to life guaranteed to them under Article 6 of the ICCPR. The Human Rights Committee in the New Zealand case, that is Ioni Tetiota versus New Zealand, stated that the obligation of the state parties to respect and ensure the right to life extends to reasonably foreseeable threats and life-threatening situations that can result in loss of life, and the state parties may be in violation of Article 6 of the Covenant, even if such threats and situations do not result in actual result of life. In the same case, Duncan Lucky Muhumuza of the Human Rights Committee, who gave a dissenting judgment, stated that the threshold should not be too high or unreasonable. The courts or the state committee cannot expect the risk to be so high that it causes death of a person. In this case, Victasia cannot wait for a death to happen in Xeronesia to accept refugees from Xeronesia. The council thus argues that the preconditions assumed by the immigration officers and other government authorities of Republic of Victasia, keeping Article 6 and the covenant as its base, is highly unreasonable. In the present case, a threshold has been achieved. The decision taken by the immigration officers is like forcing a person into a sinking boat by giving a justification that after all, there are other people on board. In the New Zealand case, that is Ioni Teitiota versus New Zealand, the committee recalls paragraph 12 of the Human Rights General Comment number 31 on the nature of general legal obligation imposed in state parties to the covenant, and points out that the obligation of the state parties not to extradite, deport, expel, or otherwise remove a person from the territory where there are substantial grounds for believing that there is a real risk of irreparable harm, such as that contemplated in Article 6 and 7 of the Covenant. It falls as a general obligation of the state, a duty of the state, to not deport a person wherein it has a substantial ground to believe that a person, when deported to the country, will face irreparable harm. In the present case, there are situations in Xeronesia like lack of job opportunities, lack of potable drinking water, which are absolutely necessary to live a life, and that too a life with dignity. It has very clearly been stated that right to life is not just merely living a life, it's a right to live with dignity in a state. Thus, the Council for the Petitioners, taking basis of Article 6.1 of the ICCPR, would like to contend that Abdul and Rehana are covered under the ambit of Article 6 and hence can avail the protection under Article 6 of ICCPR. The Council seeks permission to move on to issue number 3. Much obliged. The Article 6.1 of the International Covenant for Civil and Political Rights, 1966, states right to life. The Office of the High Commissioner for Human Rights, General Comment number 36, which exclusively deals with Article 6 of ICCPR, states that right to life does not mean only protection from someone's acts or omission, but specifically also related to enjoy a life with dignity. Again, the Council would like to state that the conditions in Xeronesia are not in a condition wherein wherein Abdul and Rehana will be living a life with dignity. The immigration officers are bound to follow the provisions of the international law, and the act of arrest will be a clear violation of it. In the summary of conclusion, that is refugee protection in international law, UNHCR's global consultations on international protection, the expert roundtable conference summary stated that specifically states should ensure that refugees benefiting from this provision are promptly identified, that no proceedings or penalties for illegal presence are applied pending the expeditious determination of claims to refugees, and that the relevant criteria are interpreted in the light of applicable international law and standards. The Council would here like to contend that the act of arrest was not at all necessary. There are other alternatives of arrest that Victasia could have approached for. For example, designated residence is an alternative to arrest that could have been opted by Victasia. This is an option that is currently being used by Sweden, for the matter of fact, and it operates a system in which a person are housed in communal houses and apartments. After that, they are recognized by the immigration officers, and then accordingly the immigration officers would come to a conclusion as to whether they have a right to live and whether they should be considered as refugees or not. The second alternative that the Council would like to state is the electronic tagging and the satellite monitoring. Here, Abdul and Rehana could have been given electronic tagging systems from where they could be monitored and their movements can be kept note of. After that, the immigration officers would promptly identify and offer them the status of refugees. The Vienna Convention on the Law of Treaties confirms the principle of general international law that a treaty shall be interpreted in a good faith in accordance with ordinary meaning to be given in terms of treaty in the context and in light of its object and purpose. Here, the Council would like to contend that all the treaties and protocols that under the international law should be interpreted in a good faith and in a broad manner rather than narrowing it down to a conclusion. The Vienna Convention stands as a leading evidence to the fact that the treaties should not be interpreted with a view to hold a person liable. Rather, it should be interpreted with an ordinary course of action and in good faith. The Council would like to submit before the Honorable Court that the arrest by the immigration officers was thus not necessary. The Council seeks permission to move on to issues 3B. Much obliged. 3B, the decision to deport the petitioner is invalid and a violation of the international laws. The principle of non-refoulement is the cornerstone of asylum and the international refugee law. The principle of non-refoulement guarantees that nobody should be returned to a country where they would face cruelty, torture, persecution, degrading treatment, or irreparable harm. The Council here contends that if Abdul and Rehana are deported back to Xyronesia, they will face irreparable harm because of the lack of natural resources and the scarcity of the resources in Xyronesia to hold and to sustain a population of 5.7 crore people. Article 33 of the Convention and Protocol on the Status of Refugees talks exclusively on prohibition of expulsion of the refugees. It states that no contracting state shall expel or return a refugee in any manner whatsoever to the frontiers or territories wherein his life or freedom would be threatened on accounts of his race, religion, nationality, membership of a particular social group, or political opinion. The article highlights the issue of refoulement and states that no contracting state. Here, the Victatia and Xyronesia are both signatories to the convention, and hence they have no right to expel or refoul a person from their territory in any manner. The word any manner plays a very pivotal role in bringing about the point that return of a person to a country or origin, or in case of a stateless person, the country of his former habitual residence, and also to any place or country wherein that person has a reason to fear threats to his or her life or freedom related to one or more grounds is highly unreasonable and at risk. Obligation under the 1966 Convention on Civil and Political Rights, as interpreted by the Human Rights Committee, also encompasses the obligation not to extradite, deport, expel, otherwise remove a person from the territory wherein there are substantial grounds for believing that irreparable harm exists. The Council contends that there does exist irreparable harm in Xyronesia, and Victatia will be in clear violation of its international right if it deports Abdul and Rehana. Article 3.1 of the UN Declaration on Territorial Asylum, unanimously adopted by the General Assembly, states that no person referred to in Article 1, Paragraph 1, shall be subjected to measures such as rejection at the frontier, or if he has already entered into the territory in which he seeks asylum, expulsion, or compulsory return to any states wherein he will be subjected to persecution. The article specifically uses no person, implying to all person and not restricting its interpretation only to refugees and asylum seekers. The OAU Convention governing the specific aspects of refugee problem in Africa states that no person shall be subjected to by any member state to a measure such as rejection, which would compel him to return to a territory and remain wherein his life, physical integrity, liberty would be threatened for the reasons set out in Article 1, Paragraph 1 and 2. The Council seeks permission to move on to issues 3C. Victatia has an obligation to provide asylum. There are the severe impacts of climate change and the need to protect people affected by it has been recognized by various agencies of the United Nations. In the Virtual Leaders Summit on Climate 2021, the United Nations High Commissioner for Refugees call on the states to set up their action to combat climate change. In October 2020, the UNHCR also published the legal considerations regarding claims for international protection made in context of adverse effects of climate change and disasters. The document acknowledges that some people referred to as the Council seeks extension to some of the arguments. Obliged. Climate change refugees and they have the right to claim the refugee status. The paragraph as stated there states that if the climate refugees suffered curtailment of their human rights, then the affected population may be at risk of human rights violation, and in such a situation, they should be brought within the scope of refugees as per the 1951 Convention. If Your Excellencies are pleased with the arguments, the Council seeks permission to move on to the prayer. Yes, Your Excellency. Pardon, Your Excellency?
According to, if your argument can be put in one line, what I understood is that the fear of persecution is basic of refugee claim. So in one line, your entire argument can be replied. Is it true?
Yes, Your Excellency, because they fear the threat of nationality as when it is under the grounds that has been brought in the persecution. If Your Excellencies are satisfied, may the Council may move on to the prayer. Much obliged. Yes, Your Excellency.
How do you say that only because you are, according to you, because 5.7 crore people still reside,
Yes.
minus 2 of you.
Yes, Your Excellency.
How do you say that when only 2 of you are having an apprehension that you will have, you will not be able to live properly? Can it be said to be fear or fear of persecution? Because fear of persecution is not per se fear of persecution. It has to be based on religious, caste, creed, etc. These are. How do you bring yourself into that definition? Because I don't see the definition includes a climate change victim. How do you bring yourself into that? That is all.
Your Excellency, here the matter is regarding Abdul and Victasia and the nationality, because now they moved on illegally and they are staying in Victasia. So the matter that is relating to the nationality, wherein they would be granting granted a refugee status in Victasia or deported back to Zeronesia. This is a threat that exists because it's on their nationality, because if no decision is taken, they'll remain as refugees and then no nationality would be granted on them.
Status of Abdul and Rehana can be considered within the 4 corners of definitions of migrants, refugees, asylum seekers, displaced persons, or stateless persons.
Pardon, Your Excellency?
What would be the status according to you of Abdul and Rehana? Whether they are migrants, whether they are refugees, whether they are asylum seekers, whether they are displaced persons, or whether they are stateless persons?
Your Excellency, we are contending here to include them under the ambit of refugees under the Refugee Convention. So according to the Council, they are refugees. If Your Excellencies are pleased with the arguments, may the Council now proceed with the prayer. Much obliged. Wherefore, in the light of the issues raised, arguments advanced, and authorities cited, may the Honorable Court be pleased to adjudge and declare that, first, Abdul and Rehana should be considered as refugees and should be given equal protection. Second, Abdul and Rehana have a right to life under Article 6.1 of the ICCPR. Third, Victasia should not deport Abdul and Rehana back to Zeronesia, where they face a threat to their survival. Fourth, Victasia should accept Abdul and Rehana as climate refugees and provide them an asylum, and or pass any order, direction, relief that it may deem fit in the best interest of justice, equity, and good conscience. For this act of kindness, the petitioner shall be duty-bound forever. May it please the court.
Your Excellencies, Council number 1 for the respondent seeks your permission to present the case. Much obliged. Much obliged, Your Excellencies. If Your Excellencies are well versed with the facts, the Council seeks permission to address the issues directly. Much obliged, Your Excellencies. Your Excellencies, the respondents will be presenting the case in 3 issues. The first, dealing with the eligibility of refugee status under the existing Refugee Convention. And the second issue, dealing with eligibility for right to life status under the ICCPR 1966. And the final issue, dealing with the sufficiency of international attention to the problem of climate refugees. Your Excellencies, this council would be dealing with issue number 1 and 3, while my co-counsel would address the issue relating to ICCPR. Now, Your Excellencies, proceeding with the first issue, that is, whether Abdul and his wife be considered as refugees under the existing refugee conventions. Your Excellencies, the primary contention is that every instrument has a specific object, and more particularly, when an instrument creates rights and obligations in respect of parties, the instrument must be interpreted in light of the specific objects in which it is made. This is called the purposive interpretation, and it is relevant when the dispute is relating to the rights and obligations of the parties. Now, the present case relates to the obligation of Victoria to accommodate Mr. Abdul and his wife as refugees. So, in order to determine whether Victoria has the obligation in the present case, the object of the Refugee Convention must be looked into, Your Excellencies. In fact, the Vienna Convention on Law of Treaties, by Article 31, recognizes this principle, and Clause 1 of the article reads as, "A treaty shall be interpreted in good faith, in accordance with the ordinary meaning to be given to its terms, in their context and in the light of its objects and purpose." So, Your Excellencies, now coming back to the Refugee Convention of 1951, the preamble very clearly states that this Convention of 1951 is predominantly a consolidating statute which consolidates the pre-war refugee instruments that were present before 1951. Those instruments are, Your Excellencies, the arrangements of 1926 and 28, conventions of 1933 and 1938, protocol of 1939, and the Constitution of International Refugee Organization. So, Your Excellencies, this Refugee Convention of 1951 provides for 2 definitions of refugees. One, that is consolidating all the refugee definitions in these pre-war instruments, and the second definition is an additional definition provided by the 51 Convention itself. So, now it is necessary to look into the scope of both these definitions, Your Excellencies. Now, moving to the definitions under the pre-war instruments, it is necessary to note that all these instruments covered victims of war. So, a person, in order to be a refugee under the pre-war instruments, should be a war victim. Secondly, those instruments related to specific domestic territories, and the person should be from such domestic territories. Now, in the present case, Victoria and Zeronesia are involved, and there is not a war. So, Mr. Abdul and his wife cannot be considered as war victims, and they are not refugees under the pre-war conventions, Your Excellencies.
Mr. Counsel, are they claiming to be war victims?
Indeed not, Your Excellencies. But in order to elucidate on the object of the Refugee Convention, the Council is trying to draw into its history, Your Excellency.
The object of Refugee Convention is only one. That if somebody is having threat to his life, he can move out and he can seek refugee status. So for that purpose, the convention can be read like that. It's not difficult reading. You need not tell us that they are not war victims. We know about that. As you said that the Excellency is known about the facts. So you need not tell us that they are not war victims. Have they ever claimed that they are war victims?
Indeed not, Your Excellencies, but the fear of life should...
Or maybe one of the reasons for life. What does war come? The question is whether threat to life is main thing or whether war is main thing.
Your Excellency...
The threat to life may arise from so many factors. And as this is rightly said by them that this environment will change and threat coming to them
So you need to tell us that they are not verbatim. You can mold your arguments accordingly.
Indeed, Your Excellencies. Of life is not falling within the convention reason, then this convention and this definition will not apply, Your Excellencies. Your Excellencies, specifically page number 15 of our memorial cites several decisions, Your Excellencies. 15 of the memorial. Your Excellencies, in para 1, the decision of Horwath versus Secretary of State for the Home Department is cited, where the House of Lords held that the risk, however severe, and the fear, however well-founded, do not entitle a person to the status of refugee when it is not due to a convention reason, Your Excellencies. Further, relevantly, the High Court of Australia in applicant A versus Minister for Immigration and Ethnic Affairs, which is found in paragraph 18, that is the succeeding paragraph, it clearly states that the requirement of persecution limits the humanitarian reach of this refugee convention, Your Excellencies. As submitted earlier, since there are defined objects and there are rights and obligations which are defined surrounding these objects, it should not be interpreted beyond these objects, Your Excellencies. In fact, the very preamble of the Refugee Convention also highlights that this refugee problem should be dealt with carefully, otherwise it will create undue burdens on the receiving states, Your Excellencies. In fact, in the present case, only due to the fact that Xeronesia is low-lying and Victoria is a high-lying country, there will be a severe burden on Victoria because it will be in the receiving state only, Your Excellencies, because there will be a floodgate of victims coming from Xeronesia to Victoria.
Mr. Counsel, the things are otherwise. This environment change is totally beyond the control of the people of Xeronesia. The other factors which you are citing, this could be possible that one particular group in that particular country may be creating trouble for the other group. But this is altogether different, and it is much, on a stronger footing that they can seek the status of refugee. What do you have to say on that?
Your Excellency, the Refugee Convention specifically covers such circumstances, Your Excellencies. And in fact, the courts of UK, Canada, New Zealand, America, all have highlighted that whenever it is not a convention reason, then it cannot, when the persons cannot be climate refugees, Your Excellencies. Further,
has any case arisen about the environmental change?
Indeed, Your Excellencies.
Let us go to that.
Indeed, Your Excellency. In the same page, page number 15, the final paragraph, Your Excellencies, the page, paragraph number 19, it states a decision where the Refugee Status Appeals Authority of New Zealand rejected a similar claim on the reason that the appellants did not differentially face the risk on account of any of the 5 grounds, Your Excellencies. And the next page in paragraph number 20 and 21, where in para 21 the relevant observation of the tribunal is elucidated, Your Excellencies, where in this case the argument was that climate change is differentially faced by 2 countries because one country will be an emitter of carbon dioxide and another country will be suffering due to the emission, and there is persecution, and so this second country is the sufferer and its citizens are refugees. But the tribunal clearly refused to admit this argument, Your Excellencies, because the motive is a relevant factor of persecution, Your Excellencies. Hence, it is submitted that there are specific cases which have denied refugee status for climate refugees, Your Excellencies. Hence, Your Excellencies, it is submitted that there is no element of persecution and there is no element of race, religion, nationality, social group or political opinion in the present case, and the fear also, Your Excellencies, is based on pure presumptions and predictions, Your Excellencies. The facts state that over a period of 10 years, 30 more islands of Xeronesia will disappear, Your Excellencies. But dealing with a similar prediction and assumption, in Teixeira case, which the applicants also relied, the committee, the UNHRC, very clearly rejected that claim, Your Excellencies. The Council seeks permission to present the decision, Your Excellency. Your Excellencies, page number 12 of the decision, Your Excellency. Where in para 9.3, it was held 9.12, Your Excellency, where the highlighted portion states that a duration of 10 or 15 years is sufficient for a home state to take adequate mitigation measures to come back from the aspect of climate change and its consequent harms, Your Excellencies. Here, in 10 years, 30 islands will disappear is a similar prediction as it was found in the Teixeira case, Your Excellencies. There is adequate time for Zerenasia to take mitigation measures, and as an international community, Victasia is ready to undertake mitigation measures, but the rights and obligations should be determined, Your Excellencies. In fact, the instruments on which the applicants relate, that is the Organization for African Unity and the Cartagena Declaration, are all regional refugee instruments, Your Excellencies, which have adopted climate change as an aspect. Climate change is a regional aspect, and there must be regional instruments where state parties come together and come at a consensus for defining the objects, Your Excellencies. Otherwise, there will be undue burden on one party and the other party will always be at the receiving end, Your Excellencies. In fact, in climate change, always the responsibilities are common but differential. They are known as CBDRs, Your Excellencies. So, state parties should come together and arrive at a new instrument. The existing framework should not be burdened with the aspect of climate change also, Your Excellencies, because there are decisions which clearly state that the element of persecution limits the humanitarian reach of this convention, Your Excellencies. Now, moving to the next contention, Your Excellencies. Your Excellencies, may I proceed? Much obliged, Your Excellencies. So, concluding this issue, it is submitted that there is no persecution and none of the grounds are involved, none of the convention reasons are attracted, and hence the claim of refugee status is not maintainable, Your Excellency. And now going to the next issue.
Mr. Counsel, you are arguing around the bush. There is no persecution, again you are wrong on that. There is persecution, there is no difficulty on that. Only argument possibly from your end it is coming is that this particular aspect is not covered under this particular convention. That seems to be the only argument.
Indeed, Your Excellency.
Then it is a question of interpretation of that particular convention or that particular document, how it should be interpreted. Whether it should be interpreted on those fundamental principles or those basic things that no, nothing can be looked after beyond this particular thing. Or whether it is required to be interpreted in a more pragmatic manner, more actively considering the problem which is coming to the human race as a whole.
Indeed, Your Excellency, the argument of the Council is that the element of persecution as is required under the convention is not satisfied in the present case, because the persecution is not an isolated factor, but it must be on grounds of being on a particular race, religion, etc., Your Excellency. So, as defined in this convention, the element of persecution is not present in the instant case, Your Excellency. Now, Your Excellencies, addressing the next issue, that is whether there are international instruments sufficient to recognize this aspect of climate change. Your Excellencies, before proceeding, the Council wants to clarify that a migrant is different from a refugee, and a migrant has an element of choice in moving from one country to another, Your Excellencies. People moving due to choice of better livelihood and due to fear or predictions are all migrants, Your Excellencies. Even in the present case, the movement was due to only a prediction that 30 more islands will disappear in the next 10 years. So, at best, Mr. Abdul and his wife could be considered as migrants and not refugees, Your Excellencies. Further, they have entered Victasia illegally. So, they are classified as illegal migrants, Your Excellencies. And hence, the difference should be kept in mind while adjudicating this issue, Your Excellency. Further, Your Excellencies, climate change has been recognized sufficiently by the international community, and there are sufficient initiatives that are taken, Your Excellencies. One such initiative is the Nansen initiative, which was undertaken in 2012, Your Excellencies, where external displacement due to climate was also recognized by the international community. Then the United Nations 2030 Sustainable Development Agenda also recognizes climate change and the consequent displacement, Your Excellencies. Further, the UNFCCC Framework for Climate Change also recognizes that climate change is a factor for displacement of persons. So, sufficient international attention is put to the aspect of climate change. But countries should come together. They must take steps to arrive at a consensus so as to determine their rights and obligations and frame regional conventions as it happened for Organization for African Unity and the Cartagena Declaration, Your Excellencies. Fitting the present case into the Refugee Convention will create unnecessary burdens for specific countries, Your Excellencies. Hence, Your Excellencies, it is submitted that the claim of refugee status under the present convention may be disregarded, and the present framework may not be burdened with the aspect of climate change also, Your Excellencies. If Your Excellencies are satisfied, the Council rests the case to my co-counsel. Much obliged, Your Excellencies.
Your Excellency, this is Council number 2 on behalf of the respondents seeking permission to approach the dais. Much obliged, Your Excellency. Your Excellency, before the Council proceeds with the issue in hand, the Council would like to state to this honorable bench that this entire case can be approached in two lenses. One is if Mr. Abdul and his wife entered the country of Victoria and immediately claimed asylum status, versus the facts of the case in which they have illegally migrated to Victoria and only after they were subsequently arrested are they even claiming to be refugees. So, Your Excellency, on the face of it itself, an illegality has been committed. Now, Your Excellency, entering into the issue at hand, that is whether Abdul and his wife can seek protection under Article 6, Clause 1 of ICCPR. Your Excellency, Article 6, Clause 1 of ICCPR confers three things to an individual. One is an inherent right to life, the right that shall be protected by law, and that no one shall be arbitrarily deprived of his life. The Council is not here before this court to state that Mr. Abdul and his wife do not have the right to life. All that the Council is trying to state is that in this instant case, the essentials which are required to establish that there is a right to life is not satisfied. So, Your Excellency, the Council will be dealing with this issue in a three-subfold manner. First is that the right to life in itself is not an absolute right. The second subfold is that
Right to life is not an absolute right.
indeed, Your Excellency, simply because there are certain measures that a state can take in order to prevent other citizens from being arbitrarily deprived of their life. The Council will be establishing through the arguments, Your Excellency.
Right.
Much obliged. The second subfold is that, Your Excellency, for claiming a breach of Article 6, the risk should be imminent, foreseeable, reasonable, and personal. In this instant case, the Council will also be establishing how the essentials are not satisfied. And finally, that if and when Mr. Abdul and his wife are deported back to Xeronesia, that deportation is not against the non-refoulement obligations of the state of Victoria. Now, Your Excellency, moving on to the first submission. Your Excellency, although the preamble of the Universal Declaration of Human Rights inheres in every human being the right to life, it is not absolute in nature. This is because Article 6, Clause 1 implicitly recognizes that some deprivations may be non-arbitrary. For example, Your Excellency, the use of lethal force in self-defense under certain conditions specified would not be a violation of the right to life, Your Excellency. The reason why the Council is making this statement is because the right to life involves a positive obligation on the state to fulfill the rights of its citizens by taking certain steps to protect the life of its own citizens. The facts of the case in this particular scenario is that the Kingdom of Xeronesia to state have not taken appropriate measures to protect the life of its own citizens. The Council will now be establishing how it is so. Your Excellency, the reason is because Xeronesia have failed to take adequate measures to protect the life of its own citizen, which is what led Mr. Abdul and his wife to even illegally move in the first place. Your Excellency, it is humbly submitted before this honorable bench that the state's own sovereignty comprises the right to regulate entry of non-citizens into the country for various reasons such as national security and protecting the interest of its own citizens. As the Council stated at the beginning of the argument itself, that if Mr. Abdul and his wife legally entered Victoria and immediately claimed asylum status, it would have been a different scenario altogether. But the facts lie that they have illegally migrated, and for 4 years till they were arrested, they have not claimed asylum status or refugee. Now that they have been Your Excellency, as soon as one enters into another country in the fear of being persecuted, in such a scenario, they must have immediately applied for asylum status to the Republic of Victoria. But the facts of the case clearly states that from 2017 till 2021, they have resided in Victoria, and only when they were arrested, because they were non-citizens, have they claimed the asylum status and have called in for the intervention of the diplomats. Indeed, Your Excellency.
They must have sat there in their country, applied for your country, then only they can come. That is what I was saying.
Your Excellency, the facts of the case in this particular scenario is that they have entered but have not immediately applied for asylum. That is why the Council stated that it is an illegality ab initio. Your Excellency, now the Council will be establishing how there is no imminent, personal, foreseeable and real risks to the life of Mr. Abdul and his wife. Your Excellency, as far as the United Nations Human Rights Committee's jurisprudence goes, they have laid down in various cases that when an individual is claiming to be a victim of violation of Article 6, they must showcase that it was the state party's actions which led to the violation of the right to life. Now, Your Excellency, if there is one party which can be blamed for if and any violation of the right to life, it is the Kingdom of Xeronesia. Because, Your Excellency, every state has the duty to take appropriate measures to protect the life of its own citizens. Now, Your Excellency, the Council would like to rely on two decisions of the Honorable United Nations Human Rights Committee, in the case of Bordes and Temiharo versus France, and Teixeira versus New Zealand, both of which were also relied by my counsels for the applicants. Your Excellency, the paragraph number 5.5 of the Bordes Temiharo case, Your Excellency. Paragraph 5.5, Your Excellency. In that, it was stated by the Honorable Human Rights Committee that individuals who are claiming to be the victims of violation of a state party must necessarily demonstrate that it was the state party's actions which resulted in the violation of the right to life. Therefore, Your Excellency, in the present case, there is nothing in the facts of the case or evidence that has been presented by the applicants to showcase that the state of Victoria have committed certain actions which directly put them at a risk, Your Excellency. This is simply because, Your Excellency, even in the case of Teixeira versus New Zealand, which was relayed by my learned co-counsels for the applicants, the ratio decidendi, or rather the majority opinion in that case, was that the author did not satisfy the requirements for the violation of right to life because they could not point out to an act or an omission that was committed by their state party to violate their right to life. Comparing the facts of that case to the instant case in hand, Your Excellency, it's a similar scenario where Mr. Abdul and his wife have not been able to point out that Victoria is in fact violating their right to life, Your Excellency. So that is a necessary condition that needs to be fulfilled in order to qualify to be a victim of violation of Article 6. Now, Your Excellency, the Council would like to state that when the applicants have not showcased that their right to life is violated, nor is there anything in the facts to suggest that Victoria has violated their right, then it would be wise of this honorable court to focus on the foreseeable consequences of a person being deported. So that brings me to the next point, Your Excellency, which is to showcase that in the case of VMRB versus Canada, which can be found in paragraph 6.3 of the decision of the Human Rights Committee, Your Excellency, the Human Rights Committee in this case have clearly held that claims which are made on hypothetical violations of the right to life cannot be sustained. The reason why the Council is relying on this is because the facts of the case as well as the contention of the applicant is that within the next 10 years, 30 islands are going to be submerged. So if that was the case, that is only a mere hypothesis which is being proposed. There is no proof to showcase that 30 islands will actually submerge, Your Excellency.
Mr. Counsel,
Yes, Your Excellency.
the committee cannot examine hypothetical violations of covenant rights which might occur in the future.
Indeed, Your Excellency.
Presence is a case where they are able to show that so many islands are already submerged.
Indeed, Your Excellency.
And there are surveys which are saying that if the sea level rises, the other so many islands are going to be submerged.
Indeed.
So there is a question of hypothetical?
Excellency, the Council would like to answer your question in two subfolds.
Yes.
First is that, now the Council is not denying that their islands have submerged. But, Your Excellency, the facts of the case clearly state that Abdul and his wife never actually faced actual loss of livelihood. Only out of fear that they might face loss of livelihood and life, they migrated in the first place. That is point number one. If I may complete, Your Excellency. Point number two is that the facts of the case also clearly state that Xeronesia is contending that within the next 10 years, 30 islands are going to submerge. What the Council is trying to state is hypothetical is the fact that 10 islands will submerge in, that 30 islands will submerge in 10 years is hypothetical because there is no evidence to establish that actually 30 islands will submerge, Your Excellency.
Evidence could be there, Mr. Counsel?
Your Excellency, a reasonable statistical basis has not been adduced to showcase that there will be 30 islands which will submerge. Because, Your Excellency, it has been the jurisprudence of the Human Rights Committee from time to time to state that if it is a hypothetical violation, such a claim is inadmissible to claim the violation of Article 6, Your Excellency.
Okay, okay.
Much obliged, much obliged. Your Excellency, similarly, in the case of Beidon et al. Versus France, in paragraph 4.3 of the judgment, the Human Rights Committee found that for a person to claim to be a victim of the violation of a covenant right, he or she must necessarily show that an act or omission of a state party resulted in the violation. As already substantiated earlier by the Council, there is nothing to showcase that Victitia's actions have in any way violated the right to life of Mr. Abdul and his wife, Your Excellency. So now this brings me to the point that the principle of imminence and real risk is not found in this instant case. In fact, even the counsels for the applicants relied on the judgment of Aldersberg versus Netherlands. In that case, the Human Rights Committee indeed recognized and upheld the principle of imminence and real risk. But in this instant case, Your Excellency, there is no imminent and real risk for Mr. Abdul and his wife to even illegally migrate in the first place, because the facts are very clear that they only had fear that they will face loss of livelihood, but have not actually faced loss of livelihood. So if they had actually faced the loss of livelihood and then they migrated, which is illegal in the instant case, that would have been a different scenario. But in this instant case, they have not actually faced, and they have also illegally migrated. So all the essential conditions which are required to constitute a violation of Article 6 is not established in the instant case. Your Excellency, the Council would now like to again rely on the judgment of Ian Tayshirt versus New Zealand, in which it is stated that the very jurisprudence of the Human Rights Committee states that the burden of proving that an Article 6 violation has been committed lies on the person claiming to be the victim. So in this instant case, it's very clear that it lies on Mr. Abdul and his wife. Now this brings me to the point that in that very judgment, which my applicants have relied on, stated that the author should showcase that his situation was materially different from the situation faced by other citizens of the country. The reason why the council is making this point is because it is stated in the facts that the Kingdom of Zeronesia altogether face the risk of climate change due to rise in sea levels. So Mr. Abdul and his wife have not been able to showcase to this honorable court how their situation was different from the situation of other citizens in their country, which would justify why they illegally migrated in the first place. Because if that was the case, then all the 5.7 crore people of the Kingdom of Zeronesia should have illegally migrated.
You want more Abdul and Rehanna to come to your country?
Indeed not, Your Excellency. If they had come legally and claimed asylum status, we would have been obliging, because the facts itself state that we have showed concerns towards the situation of Zeronesia. But the facts of the case is that they have illegally migrated, they have not shown that they had imminent, reasonable and foreseeable risk, and therefore they would not satisfy to claim protection under Article 6.
Mr. Counsel, your attention seems to be misfocused. You should argue more on the manner in which the document or convention should be interpreted.
Indeed, Your Excellency.
If at the time of drawing that particular convention, certain reasons or things are mentioned, they should be there, but they could be exemplary. Environmental changes and the threat coming because of that can be read into that.
Indeed, Your Excellency. Neither has the Republic of Victoria nor...
Sir, I may point out.
Yes, Your Excellency.
See, the Universal Declaration of Human Rights, that is Article 14, which states that everyone has the right to seek asylum from persecution in other country. The 1951 UN Refugee Convention, that is in its 1967 protocol, which protects refugees from being returned to countries where they seek being persecuted, as well as we have to consider Article 31 in Article 33 of the Refugee Convention. Can we ignore all these provisions?
Indeed not, Your Excellency. It was never the Council's intention to state that the provisions or the convention can be ignored. All that the Council is trying to state is if they enter the territory of Victoria and claimed legal asylum as soon as they entered, that would have been a different scenario. But the facts of the case is that they migrated illegally, they did not claim asylum status immediately, and they have not showcased how they faced imminent, reasonable and real risk when they stayed in Zeronesia. That is why the Council is trying to state that Article 6 is not violated in the instant case, but never try to showcase that Zeronesia did not face climate change or that they did not face hardship due to climate change. It was never the intention of the Council to state so. All that the Council is trying to state is in this particular situation, Mr. Abdul and his wife do not satisfy the conditions. And Your Excellency, a refugee can get protection under Articles 31 and 33 of the Refugee Convention only when he can qualify to be a refugee. But in this instant case, the facts itself is very clear that they are illegal migrants and they are not refugees, because they would have become refugees if they entered and immediately applied for asylum and then become refugee. But the facts is very clear that they are illegal migrants. Your Excellency, if I may take 2 minutes to sum up, much obliged, Your Excellency. Your Excellency, therefore, it is the case of the respondents that this very particular case falls well short of the threshold required to establish substantial grounds for believing that Article 6 has been violated. Therefore, the Council would like to conclude that the deportation of Mr. Abdul and his wife if and when it happens, is not against the non-refoulement obligations, because the Human Rights Committee in General Comment number 36 in the year 2018 stated that the risk must be personal and that it cannot derive merely from the general conditions in the receiving state. Therefore, Your Excellency, to sum up whatever the Council has stated, it is very clear that the Kingdom of Zeronesia and Victitia are both parallel and adjacent islands. Both of them face equal risk of climate change, and it is also very clear that Victitia has also shown their concerns towards the situation in Zeronesia. But the factual scenario is that Mr. Abdul and his wife entered illegally, and they do not satisfy the conditions to constitute a violation of Article 6, and therefore they cannot claim protection under Article 6, Your Excellency. If the Council may move to the prayer. Much obliged, Your Excellencies. Your Excellencies, in light of the facts stated, issues raised, arguments advanced, and authorities cited, the Council prays to this Honorable Court to declare that Mr. Abdul and his wife cannot be considered as refugees and are not entitled to any relief under the existing Refugee Convention. Declare that Mr. Abdul and his wife cannot seek protection under Article 6, Clause 1 of ICCPR 1966, and declare that other international instruments provide remedy for the issue, and extending the definition of refugees to include climate refugees is unwarranted, and pass any other order and grant any other relief that the Honorable Court may deem fit and proper in the lines of international justice, Your Excellency. For this, the Council shall ever humbly pray, and it was an absolute honor to argue before this honorable bench. Much obliged.
Your Excellencies, the Council seeks permission for rebuttal. Much obliged. Firstly, the Council on behalf of the respondent stated that the Convention on Refugees should be interpreted with regards to its objectives. But it is to be noted here that it should not be read in the letters but in the spirit. And we also need to take into concern the UDHR also should be taken into concern, which also provides asylum to all other people, not just within the definition of people who fall into the 5 grounds of persecution. Secondly, it is to be noted that while Victitia is not agreeing to accommodate the people from Zeronesia, it should be also understood that they are also an island country, which although they are not at a risk of submersion as of now, as per proposition itself, probably if there's that, as per the presumption that in the next 10 years there's going to be a rise of up to 2 feet, we do not know if that country is also going to get submerged. So if apologies, Your Excellencies. Also, at the same time, the respondent said that Article 6 of the ICCPR, it regards only to the state's action of persecution. However, General Comment number 36, which the OHCHR's General Comment number 36, which deals exclusively with Article 6 of ICCPR, states that right to life doesn't only mean protection from someone's acts or omissions, but also related to enjoy a life with dignity. So this clearly indicates that it is not just a state's action of depriving their life, but also can be of any other manner in which they are not able to live a life with dignity. At the same time, the Council also stated with regards to the lack of measures taken by Zeronesia. However, the proposition remains silent on that. At the same time, there's a fact given that there are mangroves for which 60% is under the control of Zeronesia and 40% under the control of Victitia. And as per scientific research, mangroves are good to stop flooding or submersion. They protect the country from submersion or flooding. But despite a country with only 114 islands having 60% of the control over mangroves, and another country having 800 islands with only 40% of the mangroves, the country, Zeronesia, is still being submerged. This shows that even with the natural resistance measures, country is not able to protect itself. And climate change is not something that Zeronesia's country has brought into being. Apologies, Your Excellencies. The Council would then like to come to end. Much obliged. May it please the Court.
Your Excellencies, the Council seeks permission to surrebut. Your Excellencies, firstly, regarding the point of the objects of the Refugee Convention, Your Excellencies, As stated earlier, the objects must be specific, and the Refugee Convention has specific objects. In fact, they relied on African Organization for African Unity and the Cartagena Declaration, which itself show that only regional specific conventions could help the issue of climate change. Had the Refugee Convention been sufficient, there wouldn't have been a need for the Organization for African Unity or the Cartagena Declaration itself. So a specific instrument must be formulated, and the existing convention is not sufficient for dealing with the aspect of climate change. Secondly, Your Excellencies,
So till then they should be allowed to die.
Your Excellencies, considering the imminence of the problem, state parties should come together. In the instant case also, Your Excellencies, Zoroaster kept silent till Victoria
Mr. Counsel, the difficulty is, as we know as a layman, the entire object of the convention is that if the people are in danger, they should be saved. That's all. Then they have cited some reasons as an example, that this could be the reason, this could be the reason, that other the reason. But then at that particular time, they did not have that idea of climate change. Therefore, it is not included. But otherwise, the convention is meant specifically for saving the people from persecution to the life. That's all. The right to life.
Your Excellency, since the time is up, the Council seeks extension. Much obliged, Your Excellencies. But there are, as stated during the arguments, there are several judicial opinions which state that the convention has a limited objective and the requirement of persecution limits its humanitarian reach, Your Excellencies. There is no denial that the aspect of climate change is to be looked into seriously, but it is not the relevant convention, and the state parties should come together for specifically defining their rights and obligations, which are common but differential, Your Excellencies. Now coming to the aspect of the comment, general comment number 36, which was made by the UNHRC, Your Excellencies, the same HRC in the Tessiota case held that climate change, that too a prediction of 10 to 15 years, is not satisfying the test of real and imminent risk, Your Excellencies. Further, coming to the point of mangroves, Your Excellencies, as they themselves admitted, Zoroaster has a reserve of 60% of the mangroves, but Victoria, we have only 40% for 800 islands. So we have less resources than Zoroaster, and with adequate resources, Zoroaster could take more mitigation measures than Victoria could take, Your Excellencies.
I told you that it should be only on the law point. But as you are telling about 800 islands and only 40% mangroves, shows that you are eaten away your mangroves.
Your Excellencies, it is, Your Excellencies, the 100, the denominator 100.
If in 114 islands, of that also some are already submerged, if they still have 60% mangroves, and you have 800 islands, and you have only 40% mangroves, means there you have not taken care of the environmental protection at all.
Your Excellencies, the percentage 60 and 40 is not what is left in the country. The denominator 100 is the total of mangroves available in Zoroaster and Victoria. Out of the 100%, they have 60 and we have 40. It is not out of 100, we lost 60. The entire 100 is the accumulation of the entire mangroves in Zoroaster and Victoria. And Your Excellency.
In spite of having 60%, still they are not able to protect their islands. Still islands are being submerged. That means that they have tried to protect, but still they are not being able to protect. Therefore, they want to come to your side. That is what they are saying.
Indeed, Your Excellencies, Victoria is ready for an agreement on climate change, but sending persons illegally and then claiming for refugee status is not the proper way, Your Excellencies. We are ready for a regional cooperation and to tackle the aspect of climate change, because we are also an island country and we will be facing it in the future. But this is not the way, Your Excellencies, and the surrebuttals are over. Much obliged, Your Excellencies.
We have witnessed some of the most talented and skilled students of law in action, engaging in thought-provoking and challenging debates on some of the most pressing legal issues of our time. Each and every one of the participants have demonstrated an outstanding level of expertise, passion, and dedication to their craft. Thank you to all the participants and finalists for the wonderful performances, and to all the audience members for joining us for the final rounds. I'd like to now invite Dean Ma'am to felicitate the honorable guests. ऊपर भी नहीं कर पाएंगे, एक साथ नीचे से कर देना। नीचे से ही दे देना चाहिए आई थिंक ऊपर इट्स वेरी क्राउडेड Let's have a huge round of applause for all the judges for joining us today. I humbly request the guests to kindly proceed towards the green room. On this note, we are ending the final rounds. I request all the participating teams to take up the seats up in the front rows for the purpose of elicitation later. Can we have all the participating teams come up front? Thank you. मैम ये लोग तो जा रहे हैं बिठाना है ना भावना मैम ऑडियंस जा रही है okay all right I request all the participating teams sitting upstairs to please kindly join us downstairs and take up one of the front rows. Thank you. And I request all the audience members to also take a seat. I repeat, I request all the audience members to kindly take a seat. I request all the members of the audience to kindly maintain decorum and kindly also take a seat, as we'll be starting with the valedictory shortly. I repeat, I want all audience members to kindly take a seat and maintain decorum. Thank you. पानी ले आओ यार अंदर पानी देखो ना अंदर पानी